Hello, and thank you for tuning in to the Beyond Hourly podcast, hosted by Bentham IMF. As one of the world's most experienced commercial litigation funders, Bentham IMF has invested nearly 2 decades into providing litigation finance and investment capital to plaintiffs and law firms. We offer law firms and their clients a risk-sharing partnership and a proven record of success as a leading global litigation funder. Episodes of this podcast can be found on our website, www.benthamimf.com, and on iTunes, Stitcher, and SoundCloud. I'm your host, Jim Batson, and I'm the head of Bentham's New York office, where I've been an investment manager and legal counsel since joining the company in 2014. Before joining Bentham, I spent 20 years as a trial lawyer. My role at Bentham involves assessing investment opportunities and serving as a strategic resource for the parties we fund throughout the funding relationship. Our guest today is Nick Kajon, co-chair of Stevens & Lee's Bankruptcy and Financial Restructuring Department, co-chair of the firm's Litigation Finance and Alternative Funding Group, and a member of its Litigation Group. Nick has over 30 years' experience advising clients on financial restructuring, corporate governance, and commercial litigation matters. Nick has negotiated a number of multi-million-dollar agreements with litigation funders pertaining to both insolvency and other commercial litigation claims, and has appeared on several panels to discuss litigation finance issues. Nick, welcome to the Beyond Hourly podcast. Thank you for joining us today.
Thanks for having me, Jim. It's my pleasure to be here.
Please tell us a little bit about Stevens & Lee and your practice to get us started here.
Sure. Stevens & Lee is an AmLaw 200 law firm with about 160 lawyers, primarily in New York, New Jersey, Pennsylvania, and Delaware. There are some other satellite offices in other places, but that's our geographic footprint. I do restructuring work and commercial litigation. I'm the head of the New York office. I work here in the New York City office at 485 Madison Avenue, just a couple blocks north of your office, and I've been doing this for 30 plus years. And of course, in my cases, I draw on attorneys from other groups, and in particular, doing restructuring work as a so-called bankruptcy lawyer, especially if you're representing a debtor in possession. You don't only restructure the company, you wind up suing people. Mm-hmm. And I've also done a fair amount of trustee work. Trustees investigate the insiders, find out what they did, and then sue them for having done it. So that's really, the nature of my practice. It's both, restructuring and litigation oriented, as it's a natural fit if you're playing the bankruptcy arena.
You mentioned suing people in a couple different contexts of that description. Do you find in the bankruptcy sphere, litigation finance can be useful in different aspects?
I've said this before, I think maybe when you guys interviewed me a year ago, that bankruptcy and litigation finance really are a match made in heaven. In a bankruptcy case, it is so often the case that there is little or nothing for the unsecured creditors other than potential litigation claims. But here's the rub. There's no money to pursue the potential litigation claim. So you have a speculative asset that might take several years to reduce to cash, if ever. But you can't get from point A to point B without a war chest. How does one get the war chest? You go to litigation funders. And, obviously, you have to first investigate the claims, and you'll have to do that on your nickel because you have to explain to the litigation funder why he should actually spend his money pursuing this. But the cost of an expensive litigation against a well-funded adversary and all that is entailed with it, including discovery, hiring experts, consultants, et cetera, can be covered by a funder. So that, in many instances, would provide a recovery, and maybe a significant recovery for creditors, where otherwise the litigation claims would have expired worthless.
Looking over your bio, I was struck that Stevens & Lee has a litigation finance and alternative funding group. Recently, we've begun to notice more firms creating those kinds of groups, maybe called different things, but essentially internal groups focused on litigation finance and what's sometimes called AFAs. Can you share with our listeners a little bit how that group came to be and what the impetus was for creating it?
Sure. A couple of years ago, the firm agreed to create that group at my behest. I've been involved over the years in a number of contingency fee type arrangements or alternative fee arrangements. I just did that naturally over the course of my career going back decades. litigation finance wasn't around back then, so you had to piece things together as best you can. Over the last 3, 4, 5 years, I've been involved more with litigation finance. And I started weaving those two things together, doing contingency fee work, partial contingency fee work, having a funder or not having a funder if you have the war chest. And it occurred to me that, gee, if we do this, shouldn't we let people know we do this? I had a little paragraph or so on my bio on, so if you stumbled upon my bio at my firm's website, you'd see that I did this, but it wasn't a practice group. So if you just looked at the firm's webpage, you'd never know about it. And so I said, I think we should trumpet this. This is a hot and burgeoning area. I'm doing it already. Why don't we create a group to, do it on a more formal basis and bring other people together and as part of creating a group, have a web page for it, et cetera. And so the world will know that you do this. And the firm analyzed it for about 10 seconds and agreed to do so. It made eminent sense and no one gave me any pushback. I mean, they got it right away that, yes, this is a good idea. We should do this.
I mean, obviously I'm biased at a litigation finance company, but I think that's great. I mean, you look at law firm web pages and practice groups, and sometimes it seems like you're seeing the same thing again and again and nothing stands out. I'm curious, having that group and as you say, making clear to the public with its own individual web page, do you have clients or potential clients ask you about that, point that out to you?
Yes, I have. Well, first of all, in any kind of representation, most of my practice is referral based, and for the most part from other attorneys, lawyers I know over the years, often who were adversaries in another case or representing adversaries. So you refer to your client, hey, why don't you, hire Nick? I have a conflict. Why don't you check out Nick? First thing the client does is they check out your web page, right? Before they call you. So I've had clients in those initial calls, oh, Jim Batson said I should call you. I noticed on your website you do X, Y, and Z. That's great because that's exactly what I need. Can you tell me more about X, Y, and Z? I've also had instances where I've basically gotten cold calls or emails, people I don't know who weren't referred, who Googled something like litigation finance or something and stumbled upon either my web page, my web bio, and saw that I do it, or the web bio for the litigation funding group, or LinkedIn, where it talks about how this is one of the things I do. So it's been a marketing tool in that respect, and that people see you do it, including people who you don't know from Adam, who just stumble upon the fact that, hey, I found someone with the qualifications I was looking for, so let me give them a call.
One of the things when we're talking about litigation finance, we point out that, law firms have the ability to take a case on a full contingency. They even have the ability to advance fees or expenses as part of the representation. But of course, law firms can't provide funding capital directly to their clients. Do you ever get inquiries from clients who are saying, hey, I'm just interested in getting money for myself, not necessarily for legal fees or expenses, perhaps because I've already got the case on a full contingency?
Yeah, clients don't really come to me for that. I mean, sometimes. I mean, I obviously deal with a lot of lenders or capital providers, so sometimes clients come to me for that. But they usually come to me when they have some litigation claims that they want to pursue, and or they want to pursue them on some kind of contingency or partial contingency fee basis, or they need funding for expenses, et cetera.
Gotcha. Well, one of the things that we were really excited to speak to you about today is your experience negotiating agreements with funders on behalf of clients. Very few lawyers have that as a practice area as well. Have you, in fact, had matters where you weren't necessarily bringing the litigation for the client, but the client needed funding and wanted to have a separate lawyer representing them in negotiating the funding agreement? Yeah,
we have done that. That is one of the things our litigation funding group will do for people. Another thing that our litigation funding group will do, and you should keep this in mind, Jim, is we will work for a funder. I mean, not in negotiating the agreement, but if you're looking at, say, specialized claims that you want an attorney with experience in that area to analyze, outside counsel, to analyze. And we've done that for funders, go in and kick the tires and let me know if these, bankruptcy claims or securities law claims are as good as they seem to be.
Yeah, we call that due diligence counsel.
Right.
A lot of times when we get a matter and we're looking it over, if it's not an area of expertise that we have among in-house, so to speak, among our investment managers and legal counsel, we will often engage external counsel as due diligence counsel.
So we do all that, but our favorite, the favorite thing we want to do is to represent the client in procuring the funding so that we can be the attorneys on the case, and we're happy to take economic risk, whether a full contingency or a partial contingency. The funders will usually pay you some percentage of your hourly rate, and then you're working for the upside. And I'd rather be retained on that basis than probably any other basis. I'd rather have the upside than get paid 100% of my hourly rate.
Yeah, and I think it's common in the industry from a funder standpoint, certainly Bentham's. We prefer arrangements where the lawyers are taking meaningful risk, but also receiving some amount of funding during the course of the litigation so that the motivation isn't just to try and get the case done as quickly as possible, as might be the case if it was a full contingency, versus maybe putting more hours than you might need if it was a full hourly. We look for that middle ground ourselves, and I could see why that would be preferable to you as well.
And one of the reasons I like I like the upside, obviously, but I also like the fact that I don't have to justify every hour to a client. Why'd you spend 10 hours analyzing that issue, Nick? Well, because it's the critical issue in the case, and it, justify 10 hours. The client doesn't care anymore. And I mean, the funder may, if they're paying, percentage, but even they will, the funder will probably understand the need for the work more than the client will. So vis-a-vis the client, I don't have the concern of, I see a potential, pitfall that could arise if these guys are smart enough to see it. So let me start figuring out how to get around it.
Right.
Let me have someone who actually knows how to do legal research, unlike me. Do the analysis, do the legal research under Delaware law or whatever of this arcane issue that may arise. And I don't have to justify that. And so if it does arise, we're not blown away by it. We've already had a chance to adjust our strategy so that we won't fall into that hole, that trap, right? So that always makes me sleep better at night, that if I see something that, justifies some work, I don't have to explain to a client who won't understand it why we should do this and have them think, oh, Nick just wants to run up the bill. No, Nick is trying to protect you.
Right.
And, the funders will get that. The funders say, that's an important issue. I'm glad you spent 10 hours analyzing it and then changing strategy so that we did not fall into that trap. Great job, right?
Absolutely. So I've heard you speak before on panels discussing very well-known matter, at least certainly in the litigation finance sphere, referred to in shorthand as MAG Corp, where funding was a big part of that. Can you tell us a bit about that and how it arose and what made it appropriate for funding?
Sure. In the MAG Corp case, I represent the bankruptcy trustee, a fellow named Lee Buchwald. And the case has been going on. He was appointed bankruptcy trustee back in 2003. And I represent him in the case. There was one litigation that was brought against the insiders, including Ira Rennert, a billionaire on the Forbes list, and his private holding company, Renco Group. And that was brought by contingency counsel, and we were local counsel in that matter. But this was brought back in 2003, back in the days before litigation finance really took off. And they funded the costs.
The client did.
The law firm did. The client didn't have the cash.
So the law firm funded both the fees and the costs.
Yep.
Full contingency.
Full contingency, plus they took the risk on the expenses. And the case went on for a very long time, primarily because the defendant obviously tried to do as much as they could to delay the day of reckoning. So we had a jury trial in early 2015 when the case was nearly 12 years old, and we won. And we got a jury verdict that resulted in a judgment for $213 million. And that's a great place to be. But of course, Rennert, being a billionaire, took an appeal. It was fully bonded, so there was no collection risk. But this was a all or nothing situation. All the trustees' eggs were in one basket. He had $600,000 in the bank and a judgment against a billionaire for $213 million. That's all he had. Creditors, note holders are owed over $160 million. The government asserts claims for environmental liabilities in excess of $100 million. There's nothing to pay them, just that $600,000, unless this, we're successful on appeal. Now, we had confidence in our case. We thought we'd be successful in our appeal. But what if the Second Circuit, it was on appeal to the Second Circuit, reverses? Then we're back to square one. Right. There goes your judgment. And, you have $600,000 in the bank is all you have. And then, will these lawyers continue doing it? You have a new trial years from now. So he wanted to hedge his downside exposure vis-a-vis the appeal. And he came to me and he said, I know you work with litigation funders. Do you think we could get, a litigation funder, interested in Mancorp, like sell a piece of the judgment, so to speak?
And this was the trustee, Lee Buchwald, asking.
Yeah, it was his idea. He knew I worked with funders, and he said, is there a way to parlay your relationship with funders into some kind of a transaction where we could be assured of getting some cash?
Sure.
I said, well, it's a little unique. It's not what funders are, ordinarily do, right? But we can ask. There's no harm in asking. And so I reached out to a number of funders, and lo and behold, we were able to procure a transaction that resulted in $26.2 million cash to the bankruptcy estate in exchange for a non-recourse obligation. Only if we win and only out of the proceeds, it would pay you $50 million. A 90% return for the funder. But, vis-a-vis my client, if I lose, I have nothing. This is, the pig had lipstick at that moment in time. It
right.
really did. This case looked horrible.
Right.
It was a no-asset case, not even enough money to pay the expenses, the out-of-pocket expenses. And suddenly, your very speculative asset is now a lot less speculative. If you were ever going to market this was the time.
Right, right.
And so, we went to market to try to, the trustee wanted a war chest so that if there were a second trial, he could hire lawyers of his choice if need be, hire experts of his choice. And no matter what happened in the second trial, he'd set aside some funds that there'd be some money, an 8-figure stash for creditors so that they get something.
Tell me about the process that you went through to seek funding. In other words, did you raise this with the court before you actually went out to market? And when you went out to market, how did you go about it? Did you get multiple bids? What sort of process did you follow? Because I imagine in the bankruptcy sphere, it's a little different than it might be for ordinary litigation funding.
You're exactly right. It was a multi-step process. First, we didn't go to the bankruptcy court in the first instance. We privately reached out. We ran a private auction process, in effect. We privately reached out to a number of funders. We created a virtual data room so they could conduct their due diligence. We had a number of conference calls with them to respond to their questions. And then ultimately picked what in bankruptcy parlance we call a stalking horse bidder. So I structured the transaction as a sale rather than a financing. Mm-hmm. Okay. And so what you do in a sale and what we did was you file a motion to sell the assets. It could be the debtor's business or factory or inventory. In this case, we were selling an interest in the proceeds of the litigation, whether the appeal or subsequent disposition or trial, whatever happened. If we win and we get cash, you get cash. That's what we're selling. The right to give us money that you may never get back for this right to someday, maybe if we're successful, get back X dollars. And so we file a motion to do that. There's a first hearing to approve the so-called bid procedures. Because if you're going to be the stalking horse bidder, you're going to want certain protections, because in bankruptcy, it's going to be subject to higher and better bids. People get a crack at saying, I'll pay more. And then you just did a lot of work for nothing. So, we gave the funder an expense reimbursement provision and a breakup fee, and all that had to be approved by the court at a first hearing. The defendant, of course, objected, right? Because what defendant suddenly wants his poor, broke trustee now to be well-funded, right?
Especially if there's a new trial.
Right. I'm a billionaire. You got no money. Hold it. Now you're going to have $26 million? I don't like this. So They objected. The note holders objected to, saying that if you do this, we'll get less if you win. Yes, that's true. But if we lose, we get more, right?
And that was the trustee's decision as to whether or not he thought that made sense. Nick, how did the MagCorp judge react to the funding arrangement here?
We were very pleasantly surprised by her reaction in that she just intuitively got it. We learned afterwards that while she was a partner at Simpson Thacher, she had done work for litigation funders, but we did not know that at the time we filed the motion or appeared before her. This is Bankruptcy Judge Mary K. Viscoso here in the Southern District. So it was a unique motion. You don't see this every day. In fact, you don't, at that time, you didn't see it at all. We structured it as a sale of an interest in the litigation proceeds, and debtors and trustees file motions to sell assets all the time. They sell the business, they sell the equipment, machinery, accounts receivable, inventory, whatever. They don't file motions to sell an interest in a litigation recovery. And so, the concern we had is the judge is going to say, what is this? I've never seen this before. I don't understand it. Why are you guys doing this? She understood immediately why we were doing it and very quickly shot down the objections that were raised by both the defendants, no surprise, and the note holders.
So she was able to recognize a litigation as an asset class.
Right. Yeah. She just immediately understood that this is an asset. She understood it was a speculative asset, because the note holders are saying, well, the trustee's going to get less money now. And she's like, yeah, if he wins, that's true, but there's no guarantee he's going to win the appeal. It's a speculative asset. Mm-hmm. So this is a sure thing. $26.2 million in the bank is a sure thing. And the trustee only has $600,000. I understand why he's doing this, and I'm going to defer to his business judgment, which is what courts are supposed to do in that situation when a bankruptcy trustee moves to sell an asset. We were relieved and happy.
After she approved the process, did any other bidders appear?
Right. Well, first she approved the bid procedures, which said that an alternative bidder had until a specified date to make a so-called qualifying bid. It had to be at least X dollars, and it had to come with the financial disclosure that you have the wherewithal to close the transaction. We did get a competing bidder who did show up, and that drove the price up. Actually, the way we structured the auction was we told people you can either bid more for the same interest or bid more or less for a lower return or some combination thereof. We were going to be flexible. Obviously, we'd look at the ratio. We'd also want to make sure we were getting at least $25 million, which was the client's goal. So if you bid $10 million for a small piece, we wouldn't have given it to you. So there was quite a bit of jockeying back and forth. The numbers on both sides were going up and down, and we went through, maybe 6 rounds of bidding. And so the successful bidder, the pricing improved in our favor. So the successful bidder had to pay $26.2 million in exchange for a $50 million return. But those weren't the initial numbers. Then we went back to court after the auction to obtain bankruptcy court approval of the new bid, which actually was the initial bidder, but on improved terms. And of course, the same people objected, and Judge Viscoso shot them down yet again for the same reason. That, the trustee, first of all, you guys don't know the case as well as the trustee does. He's been living with the case for 13 years. He has access to input from his lawyers, confidential attorney-client communications from appellate counsel, from my firm, from the trial lawyers, none of which the note holders have. And, he's exercising his business judgment. She also noted that one of the note holder group that was objecting, there were 3 or 4 members of the group. One had just joined the group that morning, a little before the 10 a.m. hearing. So how much do they know about this? Yeah, you joined the group. Great. Have you been living with this case for more than 10 minutes? So she shot them down yet again. And they, of course, appealed, and they sought a stay pending appeal. So we went up to the district court, and Judge Denise Coate shot them down. Uh-huh. And we closed the transaction.
Congratulations.
Yeah, it was a lot of fun.
How did the appeal ultimately play out?
The appeal was heard a few months later. It was a 3-judge panel in the Second Circuit. And we all left with smiles on our faces after the oral argument. And I treated everyone to a very expensive liquid lunch. There were steaks involved too, but there was a lot of alcohol to celebrate what we expected would be a win because the oral argument went so well. And in fact, we were vindicated. Less than a month later, the Second Circuit issued a ruling affirming our appeals. And we collected the full judgment, and including post-judgment interest, it came to $214.7 million, which is a nice collection.
Congratulations.
Thank you.
And not only did you collect, but you set a precedent, because I know now, and correct me if I'm wrong, but my impression is that the bankruptcy courts really around the nation are far more understanding when this type of bidding process in seeking funding for a litigation asset in bankruptcy comes up.
Yeah, it's, we're all hesitant if it's something we're unfamiliar with. You've seen another judge approve it, then you feel, oh, okay, this is okay, I can do this too.
Right.
I think doing the process the right way is important. And this goes for any transaction in bankruptcy. You want to show the judge that you beat the bushes, right? Not just whether you're selling the debtor's business or selling an interest in litigation. We ran a process that made sense based on the circumstances of this case. Here's what we did. In our case, we said we can't disclose the funders we reached out to because we have confidentiality agreements with them, but we could disclose how many we reached out to, and we did. And, if the judge is comfortable and you put in evidence, which we did, the judge is comfortable with the record that, in fact, you ran a process that was reasonable under the circumstances of the case, and you got a result that appears reasonable under the circumstances of the case, then it's easy to approve.
Having been through that, when you've seen similar scenarios later, or even just generally going forward, are there any things you would do differently now that you've been around the process once before?
Well, I don't think there's anything I would have done differently in the Mag Corp.
Oh, I mean, generally, any lessons that you learned from that experience that you've taken with you to subsequent matters?
Well, I did learn the lesson of no good deed goes unpunished, because the note holders who had taken no role in the case before then filed objections and, basically called me and my client names. We're breaching our fiduciary duty. How can we do that? And of course, the defendant said that too. But, when you're suing the guy for a couple $100 million and he calls you names, you wear that as a badge of honor.
Right.
So,
well, let me turn back to negotiating funding agreements. You've got a lot of experience with that. So I was wondering, are there any particular clauses, generally speaking, that you want to make sure that you see in a litigation funding agreement?
One of the negotiated issues is going to be the budget.
Of course.
Right. That's probably one of the most important issues, an exhibit to the funding agreement, but it might be one of the most important elements. You want to make sure that you have everything in there that you're going to need. And you want to make sure that the funder is willing to fund everything you're going to need. If you think you need a $3 million budget and the funder will only give you $2 million, you better find another funder. You also want to see how the money is going to be reimbursed. Funders, will generally dribble it out quarterly or something, and that's fine. I don't want to wait a year for my money, but every quarter, that's fine. And it's not just my firm, it's the other parties. You're going to hire experts. You might need local counsel or counsel. Like we had a case recently where we had to hire experts on Cayman law. The Cayman lawyers are going to expect to be paid. They'll wait a couple months, but they're not going to wait forever. They're not working on contingency. So you want to see how the payment mechanism works. Funders will usually want a lien on the recovery. That's something that has to be negotiated with the client. You're going to want to see what rights the funder has to pull the plug on you. Funders should have some reasonable outs, but not just willy-nilly pull the plug at my first whim. You want to go in with the funder as partners. Right. I mean, as the lawyer who's doing this with economic risk, I want, to know that we're partners on this deal. Now, if we both come to a realization that the case isn't as good as we thought it was, okay, we should hang it up. But I want to know that, I'm committed. So I want to know that, the funder is committed too and isn't just going to walk away. I think a very important aspect of the relationship, Jim, it's not in the documentation per se, is really getting comfortable with your funder, making sure you have the right funder for this case, that the funder understands the case, understands the complexities, the issues that are likely to arise, how long it's going to take, that the funder has realistic expectations, that this is going to be a long, hard slog because these guys are, dirty, rotten scoundrels and they're going to use every trick in the book. And we understand that, and that's okay. And we're in for the long haul. And it's the right funder. There's a good relationship to the extent the funder has direct interactions with the client. You want to make sure that the clients and the funders get along. Obviously, I want to get along with the funder, but you want the funder to be fully committed emotionally to the case too, because if a problem arises, and invariably life throws us curves. If a problem arises down the road, and it's not an insurmountable problem, but it's an unexpected problem. You want the funder to look at it with the mindset of, I'm committed to this litigation. This is a small problem. It's okay. We're not going to blow up a good deal for a little problem.
Yeah, there have been very few litigations that have gone exactly the way everybody expected it to.
They never do. Well, why do we as lawyers tell clients to settle cases? Because one never knows,
right?
Whether you're trying it before a judge or a jury, you just don't know, right? I've won cases I should have lost, and I've lost cases I should have won. And you tell clients that. You say, I don't know what's going to happen. I mean, we could make reasonable projections about timelines and the way things might play out, but the other party may do something unexpected. Even and I don't mean unexpected, meaning something very beneficial to them that you stupidly didn't foresee. I mean, they could have done two things at this juncture, and the thing that made the most sense that you expected them to do, they didn't do. So maybe they're shooting themselves in the foot. But as a result of that, you now have to change your strategy. Because
right.
You're like, when they came to that fork in the road, you were sure they were going to go left, but they went right. And you're like, oh, wow, didn't see that coming. They're probably hurting themselves, but now we have to shift gears. We have to do things differently.
Well, your partnership point really resonates with me, and I'm sure other funders look the same way. But from Bentham's perspective, we also want to feel comfortable working with the lawyer and working with the client. And one of the things we pride ourselves on is the fact that all of our investment managers have extensive, usually well more than 10 years experience as litigators. Have you dealt with funding companies where the counterpart to you to whom you're dealing with during the pendency of the litigation is not a former litigator? And has that impacted the relationship?
I don't think so. I think everyone I've ever dealt with was a litigator. Mm-hmm.
So how has litigation funding impacted your practice in terms of your ability to take on new clients?
Well, it's great. It's like having that extra tool in your toolkit. If you have a hammer's a great tool. But if you need a wrench and all you have is a hammer, you're stuck, right? You can't fix the problem. So having the litigation funding available, I mean, I use it as a selling point to clients. So I could say, one of the things I do is, I have relationships with funders, and, I know them all. I know how they work, and I can pick up the phone and they'll return my call. And, if you have a good case, if I think it's a good case, I'm pretty damn sure I can get funding for you.
Mm-hmm.
And, I can say that, and I really mean it, because if I do think it's a good case, I'm pretty sure funders will fund it. And so it lets me take on matters that maybe I otherwise would not take on. So my firm will let me take on matters on contingency. Full contingency, partial, they're fine with that. As long as, I'm comfortable with it, they'll bless it. They won't let me start writing checks to the consultants and the local counsel and the experts. We're not going to pay a couple $1 million to third parties. My firm won't, out of our own coffers. So if the client can't or won't pay the money for the experts, et cetera, I can't take on the case. So unless I can get a funder, right? So that solves that problem for me.
So in other words, your firm, under the right circumstances, is willing to not charge for any of its attorney's fees.
Right.
And in exchange for that, get some type of contingent recovery. But what your firm, and I find this to be very common, is not willing to do in a contingency setting is also pay the out-of-pocket expenses.
Which can be a couple $1 million.
For sure, depending on the litigation. So you'll partner with a funder in some instances where you're putting at risk your hourly fees and the funder's putting at risk the cost of the out-of-pocket expenses.
Right. And then also, so it's not just, solving that problem is important because you would lose the case then. You'd lose it to a competitor who was willing to write the checks, and that my firm is not willing to write. And justifiably so. I'm not criticizing the policy. I understand the policy. It's just
not
that
uncommon.
I would lose the case. The other huge benefit to the funding obviously for me or other lawyers, is that, while I'll do something on a full contingency, I prefer a partial contingency to a full contingency. Bringing a little money in as you go is not the worst thing in the world. It makes me happy. It makes the people who are working for me on the case happy because they get, that credit this year. We'd all like credit this year rather than next year or 3 years from now. And it keeps my firm happy. Like, oh, there's some cash flow here. Good, right? Nick doesn't have this $3 million receivable. Nick has a $1.5 million receivable. Oh, okay, whatever. We'll cut Nick some slack this year, right?
Right.
So, yeah, that's another huge benefit to it, and it makes it easier for me to take on the next case because I do have to bring in some cash each year.
Sure.
So if every case were a straight contingency that wouldn't pay off for 3 years, I might have a spectacular 2022, but the next couple of years are going to be pretty sparse,
right?
And so you have to have that continuous cash flow, and obviously with the funding, you ameliorate that problem.
How do you think litigation finance is impacting the legal industry broadly?
I think it's similar to what I said, in that lawyers are now catching on and getting educated to it, and can therefore educate their clients. And unfortunately, I have more competition out there, Jim. I wish lawyers were all stupid and didn't want to work with litigation funders.
Well, I'm sure your clients appreciate finding somebody who has experience with it and isn't doing it for the first time.
It's a great selling point for me. I just regret that other lawyers are catching on. Darn. You're educating them too much. Please stop.
What do you see on the horizon that will impact the use of litigation finance by clients?
Well, one thing I see, Jim, and I'm not an economist, but I noted, as probably you did as well, that the yield curve inverted last week, and it's still inverted as of today. That is generally a harbinger of an upcoming recession. Now, it may still be a year away, but we have to, bearing in mind that this recovery has been going on for about a decade, so it's already long in the tooth. It makes sense that at some point, maybe sooner than later, there's going to be a recession or maybe a slowdown, and that affects companies. It'll mean more bankruptcies, but beyond the modest percentage of companies that file Chapter 11, all companies feel the squeeze in a recession. And what do you do when you feel a squeeze? When sales start dropping because consumers or the companies you sell to are cutting back, you cut back too. And what's one of the easiest expenses for a firm to slash? It's litigation budget, right? Companies they see that we're heading into tough economic times. They're looking to lay off workers. They cut sales and marketing. They cut their R&D budgets. But all those are valuable things that that directly impact the bottom line. Litigation budget, they view it as, why do we need to spend money on litigation? How does that help us? Maybe we'll get a recovery several years from now. So what? We got to reduce our litigation budgets. And so a great selling point, if times are tough and a company does not have the money to spend on that extra litigation because they've been told they got to slash their litigation budget by the CEO, the CFO, and their general counsel, well, gee, you don't have to spend anything on this valuable litigation claim you have. Zero is the cost to you. The funder will pay 100% of the cost, the attorneys, the out-of-pocket expenses, everything. And that could be very attractive or more attractive when companies are feeling the squeeze. If you're a company, if you hire lawyers on contingency and you have a funder involved, obviously you're giving up some of the upside to both of them. So if you have a valuable litigation claim and you only have to spend $1 million to prosecute it, you think you're going to get $50 million, well, maybe that's a no-brainer. If you don't have the $1 million because you've had to cut back, then all of a sudden giving up that upside is looking a lot better. So I think with, if and when there's a slowdown or a recession, you could see more companies suddenly realizing that litigation funding is an attractive alternative when they're in the midst of a liquidity squeeze.
For our last question for the audience, Are there any actionable takeaways that you would recommend for the listeners here?
I think one of the most important things for lawyers, if I'm giving advice to other lawyers, I probably shouldn't, but I will, is that, have that extra tool in your toolkit. You'll get that case that you otherwise would not get, because now a client is suddenly going to talk to you because you can offer something that previously you could not offer, and many of the other lawyers that they're talking to could not offer, and you'll be able to take on the case, right? So if a client came to you and said, gee, Jim, we have this really great $100 million lawsuit against a deep pocket, and it's not time barred, we're not aware of any defenses. Here's a memo explaining it, but a lawyer isn't willing to take it on because we have no money to pay it. Will you take it on? And you analyze the case and you realize you're going to need, even if you were to do it on a full contingency, you need to spend a few $1 million on experts. You say, I can't carry it. I can't do that. Sorry. Well, won't you pay the $3 million? I think it's a good case too. No, we don't have it, or no, we can't take the hit on our P&L. We're not willing to do it. Now all of a sudden you can take on this $100 million case that you think has settlement value of $50 or $60 million, and that's a nice payout.
Indeed, and I think that's a perfect spot for us to wrap up today's podcast. Nick, I want to thank you for appearing on Bentham's Beyond Hourly podcast and for sharing your knowledge.
Thank you so much for having me. It was a pleasure.
As I mentioned at the outset, episodes of the Beyond Hourly podcast can be found on our website, www.benthamimf.com, and on iTunes, Stitcher, and SoundCloud. We'll be back soon with another episode focused on advancements in legal services that drive economic value for law firms and the clients they serve. Until then, I'd like to thank our audience for listening in and invite you to follow up with me, Jim Batson, at jbatson@benthamimf.com for any feedback, ideas, or insights you have on topics we should cover on the podcasts going forward. Thank you and be well.